565, come on up here. Your name, Mr. Crawford?
Michael Crawford, representing the defendant.
Sir, your name again, Mr. Ward?
Eric Ward.
Raise your right hand. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant?
I swear.
And the parties here?
I swear.
Okay. And you're a certified interpreter, right?
Yes.
All right. This case been going on for a while. Your name? Okay. I'm ready to set it for trial. Does he want a jury trial or does he want a bench trial?
Your Honor, it's my understanding that my client is now suffering from pink eye and he would like an adjournment.
Listen, I want you to tell him this. We try to provide fairness here. You don't get to bring interpreters into the courthouse every time you come here. I will also remind you that I was convinced by staff that you actually can speak English, but I'm doing everything I can to accommodate you with an interpreter. This is it. We've had too many court dates. This isn't a murder trial. You were here June 25th. You were here July 9th. You were here July 23rd. And now you're here August 6th. We are either setting this case for trial today or it's being resolved today. If you have...
When courtroom excuses hit the limit, this is what it looks like. The defense says pink eye. The judge says zoom from the parking lot. He's done with delays. Every wasted appearance costs time and taxpayer money. And this judge isn't buying another sick note. This moment isn't about illness, it's about accountability.
Such a bad condition of pink eye, you can go out in the court, go out in the parking lot, and you can Zoom with your lawyer. I have no problem with that. If you called ahead, that's what I would have said, but I'm not going to keep adjourning this. These guys are charging a lot of money, and guess what? If there's a conviction, you're going to get to pay for it. So let's stop prolonging the case and either resolve it or go to trial, period. You got it? I asked him if he understands.
I don't feel well.
Go out in the car. Go out in the car. If then we can just set it for a jury trial or a bench trial, as the case may be. I'm not going to keep... Taxpayers are not going to pay for these people to come in here. What do we get, $160 an hour, I think, we're paying these interpreters? We're not doing this. So does he want a jury or a bench? I don't want to hear any more of your excuses.
Your Honor, can we recall this map so I can talk to my client?
Here's where it gets tense. The judge accuses the defendant of faking a language barrier. That's explosive. If a judge suspects you're gaming the interpreter system, credibility evaporates instantly. When he says, "You just shook your head when I spoke English," that's game over. Courts respect language barriers, not manipulations.
He's always got an excuse, it seems like.
I know.
Well, you understood what I said, didn't you? You just shook your head. Hey, you just shook your head when I spoke English. You understand English. Don't play with me. I'm not a toy. Now go out and we're either setting this for bench, we're setting it for jury, the prosecutor's dismissing it, or there's going to be some other form of resolution today. Period.
Thank you, Your Honor.
Thank you.
By this point, the judge has drawn his line in concrete. Trial or resolution today, nothing else. This isn't anger, it's efficiency. Too many extensions mean justice delayed, and delayed justice is broken justice. This clip shows how firm judges protect both fairness and time.
David Istelhart Gonzalez. This is file number 25W836565.
Michael Crawford, representing the defendant.
Come on up here, gentlemen.
So state your name for the record.
David Estivar Gonzalez.
If there's restitution, there's no civil liability really, right? I'm not gonna take a no contest plea. It's either going to have to be a guilty plea, and that's fine, attempt MDOP, but when there's a some certain, that's not gonna fly with the civil liability.
Well, part of the rationale, there are some concerns about his citizenship status and providing a record that could somehow undermine that status. So, some liability concerns there.
I just can't, I don't wanna treat people different. I think I'm treating them different. I don't,
Well, then let me talk to the prosecutors.
well, why can't he just plead guilty? I don't understand.
Well,
You don't think immigration officials are gonna look at it differently based on whether it's a guilty plea or a no contest plea, right?
we're concerned about him providing testimony about his behavior, how that could play out in another circumstance.
Call in the prosecutor.
Sure, Judge. Thank you.
Your name?
Good morning, Your Honor. Again, William York. I have to say, what Hicks.
So I really don't want to do these no contest pleas. I want to make sure that you guys have, gentlemen, I want to make sure I have your undivided attention here.
Sorry, Your Honor.
This part is legal gold. The defense wants no contest to avoid self-incrimination, but the judge refuses. Why? Because the restitution amount is fixed. That means liability is crystal clear. A no contest plea works only when guilt isn't certain. Here, the damage is proven, the mirror's broken, and there's no wiggle room left.
I don't really want to do no contest pleas when there's a some certain, like, there's no other cause of action other than repayment of the damage. So when we say civil liability and there's an agreement as to the amount of restitution, it doesn't make a lot of sense. So I'm explaining to them that I would take a plea to attempt MDOP. I don't have a problem with that, but it's going to have to be a guilty plea.
Very well.
So does he want to proceed with that?
Can we recall, Your Honor? Just give me a moment.
Okay, sure.
Get you know.
That's the problem, you know. If I do it for him, I got to do it for everybody else. That's the way I look at it. So I just can't justify that. So that's going to have to be it. Henry, Destiny, Danae Henry. This is file number 25W83780.
Morning, Your Honor. Michael.
What are we doing?
I'm just gonna move forward, Your Honor.
People against David Escolar Gonzalez, 25W8366565.
It's Michael Crawford, representing the,
All right, Mr. Ward, you're still under oath. Your name again?
Eric Ward.
Your name again?
David Estivar Gonzalez.
All right. So now, as I understand it, it's going to be a plea of guilt to the charge of attempted malicious destruction of property,
yeah, that's correct, Your Honor.
with the understanding that the malicious destruction of property will be dismissed. and that there will be agreed upon restitution of $1265.50 to the victim of the case, correct?
Correct, Your Honor.
Do you understand that?
Sí. Yes.
Do you agree to that?
Sí.
Yes.
Did the interpreter explain the advice of rights and cover all these with you?
Sí.
Did you read them and understand them? Did he read them to you and did you understand them?
He read it to me.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
To the charge, attempted malicious destruction of property, how do you plead?
Sir, are you pleading guilty today?
How do you plead to attempted malicious destruction of property?
Guilty.
This is where the courtroom slows down on purpose. Every guilty plea has to be ironclad. The judge repeats rights, penalties, and consequences, so no one can claim confusion later. It's not bureaucracy, it's legal armor. Once a defendant says guilty, it's a permanent signature on their record.
Which, by the way, you understand the possible penalties, correct? Up to $250 in fines, 45 days jail. Court costs are all of those. You understand that?
Could you repeat that, please?
The possible penalties, the maximums, these are the maximums, up to $250 in fines, 45 days jail. Court costs are all those. Do you understand that?
So would that be all of those or just one?
Can be all. Those are the maximums.
When will that be defined?
At the sentencing.
What can I do to avoid jail?
I didn't say I'm sending you to jail. I'm going to order a pre-sentence report. I don't know enough about you. I didn't say I'm sending you to jail. I just said that those are the maximums. I have to tell people what the maximums are. You understand that?
Yes.
All right. Knowing all that, you still wish to plead guilty.
Yes.
And you understand by pleading guilty, you're giving up all your rights.
Yes.
To the charge attempted malicious destruction of property, how do you plead? How do you plead, guilty or not guilty?
I thought it was attempted at the original.
Did I not say that? Did I misspeak? To the charge of attempted malicious destruction of property, how do you plead?
Guilty.
Were you at the Woodhaven Police Department on May 2nd of 25, located at 21869 West Road in Woodhaven?
Estaba en el departamento de policía de Woodhaven, Woodhaven, en mayo, en dirección de... I didn't know if that's where it was, but that seems like the right address.
Did you intentionally damage an individual's side view mirror
Nos hizo daño al espejo retrovisor del lado de ya estaba dañado, pero creo que yo lo terminé dañando. It was already damaged, but I think I did cause more damage to it.
how did you damage the side view mirror?
¿Cómo se dañó el espejo retrovisor? Con mi pie. With my foot.
You kicked it, correct?
Sí, me caí. Yes, I fell.
Are you on probation or parole? You what?
What? Can I say it? When I kicked it, I fell.
You intentionally kicked his side view mirror, right?
Yes.
And just like that, the courtroom freezes. After 4 hearings claiming he can't speak English, the defendant suddenly answers in perfect English. The judge catches it instantly. That moment flips everything, from sympathy to suspicion. It's one of those courtroom shocks where silence says it all.
True or false? Why are you suddenly speaking English?
Because I'm getting confused with him.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty? Anybody force you to plead guilty?
No.
And you understand, as a result of this plea, I'm not saying it's going to happen, but there could be immigration consequences to this plea. Do you understand that? Or deportation consequences, I should say.
Could you repeat that, please?
Do you understand there could be consequences to this plea if you are not a legal? I don't know the status. I don't want to know your legal status. But you could potentially be deported. I'm not saying it's going to happen. You could potentially be deported as a result of this.
This final warning hits harder than any sentence. Immigration fallout. A guilty plea can trigger deportation, even for minor charges. The judge isn't threatening. He's reminding. Every plea carries weight beyond the courtroom. Freedom always comes with paperwork, and one wrong signature can change your entire life.
Plea and conviction. Do you understand that? You understand that, right?
Sí, pero no es un crimen de monto. Yes, but it's not a crime of moral turpitude.
All right. I'm not going to debate the law with you. I want to make sure you understand there could be consequences. Do you understand that?
Yes. Yes.
And you still wish to plead guilty?
Yes.
This is the United States of America. You do have choices. You just, for the record, stated in English, I have no other choice, even though you've been telling me for 4 court appearances you can't speak English. You speak English well. I don't know why you've been playing with us.
Problem is that.
Just listen, I don't want to go into it. I just want you to know there could be potential consequences to your status. And as long as you're telling me yes, and I still want to plead guilty, I'm taking the plea. If not, we'll set it for trial. You still wish to plead guilty? I'll accept the plea. I think I still want a PS, and I'm dismissing the, I'm dismissing the PSI. I'm sorry, dismissing the malicious destruction of property. I'm ordering a pre-sentence report. Tell probation we're sending them over. No contact with Carl Lucas. No contact with prosecution witnesses. No firearms. No weapons. And he did go over and get printed, right? Let me see here. Yes, he did. So we'll have a sentence date. Lisa, what can you do for me?
September 3rd at 8:30.
September 3rd at 8:30. Okay? So tell them they're coming over now. I wish you well. Thank you very much, Mr. Ward. Good luck, sir. Go down the hall, get your notice, go over to probation where you'll be interviewed. Thank you.